Okay, I think we can make a start. Good afternoon, everybody. For those who know me and those who don't know me, I'm Paul Hennity, who's a Senior Associate in the Employment Department at Aarons. And this is Natalie Howitt, who's a solicitor in the team. And we're presenting today from our Wirral office, which we've been in for now nearly 12 months. So good afternoon. And today we're going to talk about settlement agreements. And we're going to talk about it from the point of view of an advisor rather than sort of advising on how to draft settlement agreements or how to offer them. Obviously, part of our job day to day involves advising employees on settlement agreements. That sort of job, people ring us up and say, I've been offered a settlement agreement by my employer. We get to see a variety of reasons why they may have been offered. But when we are advising, we do tend to see quite a lot of errors, and we see mistakes that employers make when preparing the documents and giving them to the employees. And we thought it might be helpful to you guys to or for us to tell you about those mistakes, and then hopefully that can minimise problems that can arise. Obviously, when you are giving someone a settlement agreement, it is an important document, potentially paying that person a lot of money, and you want to have the appropriate protections in place. One thing which to take away from today, which we think is important, is that generally speaking, when you are sort of negotiating a settlement agreement with an employee, both parties are working towards the same aim. The employer wants the agreement signed, and they want the protections of the waiver of claims, whilst the employee may want more money, but ultimately, they are also sort of accepting that their employment is going to terminate. Quite often, I will say to an employee who is in the meeting with me, the reality is the employment relationship is now at an end, or shortly will be coming to an end, and it's about getting you out on the best and the most fair terms possible. So that's kind of the background. We're going to go through kind of our top 10 things that we see in settlement agreements which causes issues when we're advising employees. Natalie's just going to briefly explain now about the obligations of the advisor on the settlement agreement.
So, hi everyone. So for a settlement agreement to be effective, the employee must have received independent legal advice on the effect of the agreement itself. So the effect of the agreement relates to the waiver of claims. So the extent of our advice as solicitors to sign off an agreement only extends to the waiver of claims itself and how that operates in practice. So we're not there to advise an employee whether we think the agreement's a good deal or not. Therefore, we're essentially just there to explain to the employee that by signing the agreement, they're waiving their rights and their ability to bring claims referred to or specified in the agreement.
That's absolutely right. But what you will probably be familiar with, and if you have a settlement agreement or you use our agreements, then you'll be familiar with that the contract actually contains a lot more clauses than just the waiver and the kind of payment terms. The reason for that is because we want to maximise the protection that the business is going to get from the terms that are in the agreement. So that's why we see the clauses, for example, relating to confidentiality, company property, perhaps restrictive covenants, repayment terms. They're not necessarily the job of the advisor under the statutory requirement to advise on the terms of the agreement as an independent advisor, but they're in there because the business wants additional protections in exchange for the money that it's paying, as well as obviously the protection from the tribunal claims. And that's why we sort of see longer documents than just sort of, this is your money, this is your waiver. So our top 10 gripes, I suppose, to start off, the most annoying one, which we do see from time to time, and certainly one that probably creates the most issues, relates to taxation around the compensation payments. Most agreements that we see, fortunately, will set out the notice pay provisions separately from the compensation. So you say, for example, you're entitled to 12 weeks notice, that will be paid as a pile-on in lieu, subject to tax, national insurance, and then any compensation payment will be clearly marked as separate from that. However, and because prior to 4 or 5 years ago, you could do this until HMRC get wise, employers agree to waive notice periods and say, we will just pay you a tax-free lump sum. The problem with that now is that we as advisors are unable to sign off that agreement because you're potentially facilitating tax evasion, because HMRC would have been due the notice and national insurance contribution, the tax and national insurance contributions on the notice period. So, for example, if you offer an employee the lump sum of £20,000 and tell them it's going to be tax-free. They ring us up and say they're getting 20 grand. They then come to us for an appointment and we say, well, hang on, unfortunately, because you've got to work or should have worked 12 weeks notice, HMRC will want the 12 weeks worth of tax and national insurance contributions that you would have paid on that notice period. And that therefore is going to be deducted from the £20,000 that you thought you were going to receive. The problem that then creates is you've got a person who's come to you thinking they've agreed and accepted to take £20,000 tax-free. They're now finding out they're only getting £16,000 or £17,000. Who's going to make up that difference? And it ends in a dispute with the employer. And then obviously the solicitor has to go back to the employer and explain it to them. Sometimes the person who's dealing with the settlements, but on the other side at the employer doesn't necessarily understand the consequences of it, the tax issues, and it can create issues. So having a true understanding of the what's it called, post-employment notice plate situation, and understanding that tax will have to be paid on the notice, even really in circumstances of gross misconduct, because you are coming to a mutual agreement, even if you wouldn't have paid them notice because they were getting dismissed for gross misconduct. Really, it's going to cause, if you're going to sign a settlement agreement and the solicitor is going to sign it off, then really you're going to have to make sure that the appropriate deductions are for tax and national insurance. We as a firm won't sign them off under any circumstances. That's our firm policy, because we don't want to be associated with the potential tax implications of signing it off and allowing the payment to be made tax-free. Some solicitors take a different view and have a slightly less strict approach, because they believe that the indemnities in the contract can be sufficient to allow that if tax is deemed payable, that the employee will have to pay, and provide that explains to the employee, that's okay. But you just don't want to have to go to that conversation where you think you're going to have to pay a certain amount, because the situation is basically either the employer agrees to top up the payment so that effectively the net sum becomes the gross sum, and then they have to pay the tax and national insurance on top, or then tell the employee, sorry, you're only going to get less, and that can obviously then put the agreement in jeopardy. So that's the kind of first one.
So the second one is specifying the claims, or failing to specify the claims. So the current view of the courts and tribunals is that a catch-all waiver of claims within a settlement agreement is not effective. Despite this, many employers still choose to include a catch-all waiver of claims and not specify the claims relating specifically to the circumstances. It's unlikely to be a problem in itself, as long as the employer is aware that such a clause may be susceptible to a legal challenge down the line. Often an employer will list specific claims alongside a catch-all waiver. And there was a case that kind of brought this to light. So in the court, in Hinton and University of East London, the Court of Appeal held that a settlement agreement must clearly identify the statutory claims being settled in order to be binding waiver of those claims. Therefore, when drafting a settlement agreement, it's not just a case of changing the names at the top of the agreement and the address. You've got to have some thought behind it. So, for example, if you've got an individual who has potentially been discriminated against based on their disability, you'll have to list this as a specific claim, as well as including it in the catch-all waiver of claims as well.
Yeah. So, for example, if the last person you gave a settlement agreement had a potential maternity claim, and they acted with the specified claims, unfair dismissal, maternity discrimination, as the two specified claims that you're going to waive under the agreement, if you then change the name and address and the next person who's getting the agreement is a man, then obviously a maternity claim wouldn't be relevant to that male employee, and therefore, the specified claims wouldn't be appropriate to that individual. So what Hinton said was, you can't just waive everything anymore. You've got to actually think about the circumstances of the termination and identify which claims are being waived in order to get the maximum protection. Now, the reality is, in some cases, people sign a settlement agreement, think they can't bring a claim, and that's the end of it. But it was subject to challenge in Hinton, and that was what the court found, that if you don't specify the claims, the appropriate protection isn't there. So potentially, you could find yourself in a situation where the employee has signed a blanket waiver of claims, and then goes, actually, my specific discrimination claim wasn't waived. I'm now going to challenge that. The agreement's unenforceable. I want to take to the tribunal. So you don't want to find yourself in that situation. Number 3 is issues relating to legal fees. So you'll be familiar that most employers will offer a contribution towards legal fees. It's not a legal requirement to do so, but trust me, it's the best way to get the employee into the solicitor's office, and usually that's the start of the negotiation towards the exit once they've appointed a solicitor. Sometimes the agreement will just say the employer will pay the legal bill, and sometimes it will say the employer will pay the bill, but it needs to be upon receipt of an invoice addressed to the employee but marked payable by the employer. There is a reason for that. The reason for that is to do with VAT, because the service that we deliver, the VATable service, is to our client, the employee, not the company. And therefore, the company isn't entitled to claim the VAT back in the usual way because they haven't received the benefit of our service. The service has gone to the client. So when we send our invoice in, so first of all, make sure your agreement says that it should be payable by the employer but addressed to the employee. And secondly, when you receive our invoice that's set out in that way, and that you pass it on to the person who pays the bill, whether it's the accounts department or whatever, you explain to them and say, this is why the invoice isn't addressed to ourselves, because we've got a clause in the contract which allows it to be paid in this way, or needs to be paid this way. Because quite often we'll send our bill, it gets forwarded to accounts, and then the accounts department email and say, this bill's not been addressed to us, we're not paying it. And we have to sort of then go back and say, well, no, that's what your agreement said, how we pay it. And sometimes people at accounts can't rationalise that as a kind of acceptable way of paying. We're not paying it, and so you contracted to pay it, and it just goes on and on. When actually there is a real valid reason for that. It's not just a sort of anomaly as to why it's been done in that way. And obviously, again, you don't want to be in breach of the VAT legislation if you're claiming VAT back for which you're not entitled. So just remember that if you do receive your invoice from the solicitor for the contribution towards fees, that whoever's going to be paying it, just explain to them why that is. Bearing in mind, of course, that there may be other clauses in the agreement which may relate to confidentiality, which you obviously have to be, and that creates a problem for us if we're having to deal with someone who might not be familiar with the person who's been exited. So it does make life a lot easier if you just deal with it in that way.
So the fourth issue is possible unreasonability. So a big frustration for us is when an employer only provides a PDF version of the agreement. It's likely that the solicitor is going to have a few minor amendments, and to save time, it's generally just easier to provide a Word copy of the agreement. Another issue is if we only see a PDF and requested to make the amendments via email. Again, this just causes delays. So solicitors are reputable and they're not going to sneak clauses in. And most companies nowadays have software to kind of show any changes which have been made to the agreement. And it's more than likely that any of the amendments which are proposed are going to be suggested through track changes, which obviously as an employee you can just accept or reject. If you are worried about clauses being stuck into the agreement without you knowing, there are ways of protecting this position. Obviously we can assist and advise you with this if there's something that you're interested in. Another issue is not being provided with the contract of employment. So there's often clauses referred to in the contract, such as notice, as Paul's already touched on, confidentiality and restrictive covenants, which are usually referred to in the agreement itself. So to save time, again, it's just useful to have a copy of the contract of employment when it's sent with a settlement agreement itself.
Yeah, absolutely. Yeah, when we ask for a Word version, we're not trying to sneak in secret clauses and think how we'll catch out the employer. Then it goes back to the collaborative approach. It saves time rather than us writing an email or a letter saying you need to change all this. If we can spend that time, that contribution towards legal fees, doing a track change, sending it to you for consideration, and having a back and forth on a single document, it's far easier to work like that. If we're negotiating a settlement agreement with another solicitor, that is how we would do it. It's just kind of frustrating to have to deal with a PDF and say, well, on the basis that the other side don't really trust the person who's acting for their employee. We're not going to sneak in what terms which are unfavourable to the employer. And also, even if we did do that and it wasn't brought to your attention, the likelihood is that a court wouldn't enforce it anyway because you've kind of been underhand and not acting in good faith. So that's not a legitimate concern. And so a Word version that can be track change, amend, comments added is a much more practical way of dealing with things. One thing which we quite often see as well now, and this is relatively recent, is the Law Society has published guidance relating to confidentiality and basically gagging clauses in settlement agreements. You'll be familiar with the confidentiality clause, which says you can't tell anyone about the terms of the agreement, the negotiation, the reasons for your exit, which is all fairly standard and agreeable. And there obviously are caveats to that. Obviously, you can tell your solicitor if you want to take any financial advice on the compensation payment. You usually can tell an immediate family member or a partner, provided they keep it confidential too. Employers will have similar clauses if they need to tell their accounts team, as I said earlier, then that can be done as well. But what a settlement agreement must not be is an entire gagging clause where confidential information cannot be sort of mentioned in any circumstance. So, for example, in cases of particularly whistleblowing, health and safety breaches, reports to the police, reports to HMRC, regulatory investigations if the type of work you're involved with, is regulated, and any disclosure required by law actually now have to be set out in the agreement as the exceptions to confidentiality. For example, if you had a situation, say, where an employee had signed a settlement agreement that was going to continue working for a couple of weeks, they then they noticed or found out about a serious breach of health and safety, someone who was, acting illegally in the workplace, and they thought, oh, I can't tell anyone that because I've signed the confidentiality agreement. I don't want to lose my money under the settlement agreement. You're going to be exposed as a business, and actually that clause would actually be entirely unenforceable and probably illegal. And the person who'd signed it off, in terms of the lawyer, would be, potentially professionally in trouble, because the regulations, the Law Society guidance is that solicitors should not sign off settlement agreements where there's a blanket confidentiality clause. So it's really important to make sure that clause is in the agreement, and you are setting out the exemptions to the confidentiality.
6, signing and dating the agreement. So first I'll touch on sending the settlement agreement when it's already been signed. So we've had issues in the past where kind of the financial aspects of the agreement have been incorrect and drafted in the favour of the employee. So I think we've had where 2 lots of notice pay has been included in the agreement itself. So as I mentioned earlier, it's not in the advisor's remit to advise the employee not to sign the agreement if we notice an error. We're not there to say if it's a good or a bad agreement. And should the employee choose to sign it as it's been drafted, and if you've already signed the agreement, it's technically binding, and you may face breach of contract issues if you don't choose to honour the clauses in the agreement itself. Secondly, dating the agreement before obviously the parties have signed it as well. So some employers seem to date the agreements on the day they provide the agreement to the employee. This causes a number of issues with certain clauses in the agreement. For example, asking the employee to return property on or before the date of the agreement. So as you can imagine, it's going to be a date in the past, and then the employee would already be in breach of this term. Also, depending on how the wording in the advisor's certificate is drafted, it may refer to the advice being given on the date of the agreement, which again won't be accurate and it will be incorrect. So realistically, the parties should sign the agreement, and then it should be dated once both the parties have signed it.
Okay. Again, sort of issues, well, number 7 we've got here, but a lack of clarity in the agreement is also not helpful. Lawyers like contracts, obviously, because contracts make things clear. But even more than just contracts, we like contracts that are clear and they are easily interpreted, and that both sides know what is being agreed to. Things like not providing the dates of payment. So quite often you'll see the termination payment will be paid within 14 days, then it doesn't say anything in relation to notice pay or holiday pay, or when that will be paid. Usually it's paid in the next payroll, but sometimes it says things like paid in the usual way. But if you're coming to a lawyer who's no idea what the usual way is, that doesn't really help us sort of tell the employee when they're going to get the money and when they can expect to receive it. Sometimes employees want to know, particularly if it kind of falls into 2 tax years, as to when the money's going to fall in. Freestyling is certainly something that we see from time to time, not that often, but if someone has something unusual that they would like to have negotiated into a settlement agreement, perhaps they might be, taking some company property, they might have some intellectual property that they've created, and they want to the employee is going to take ownership of that. Things like, not necessarily unusual, but there might be a transfer of a mobile phone, there might be transfer of a car, laptop, things like that. But then are you actually, so yes, you might say you can have your mobile phone, but actually are you thinking, well, who's going to look after the contract once the transfer's happened, or once the termination's happened? Who's going to be liable for the bills up to a certain point? Who's going to keep the phone number? Who's going to sort out transferring the phone number? Same with cars. Who's going to look after the insurance? Who's going to pay for the petrol? All those things that actually you have to think about. It's not just as easy as just transferring the car. So if you are looking at a situation where something is not quite the same as, exiting payments, finish on Friday, thanks very much, then probably you need to get legal advice, because there is always other things to think about than people who just try and have a go themselves. Holiday payments and notice pay, always a good idea, just to tell the employee how much holiday they have. Any holiday, it's all right, but if they want to know, then they also might want to know the figure. When we draft them, we try to include both the figure and the number of days. Same with notice pay, the figure, because it allows us then to say how much you earn, what's your notice pay on your contract. Let's double check it's correct, and hopefully it will be. One thing which I always find quite sort of funny in terms of confidentiality restrictions is when you tell someone that they mustn't talk about the fact that they've left. Well, obviously, if you've worked somewhere with your colleagues and all your friends who don't work at work know that you work at a place, and then suddenly you don't work there anymore, that's going to beg a question. So perhaps having something in the agreement sensible to say, safe to say I was made redundant, or safe to say I left by mutual agreement, type of thing, just because obviously it does seem a bit daft that someone should just disappear from a business and never mention why or why they left or anything like that. So just practical things that are helpful to think about. One other thing is we quite often see is repayment clauses. So if you breach the terms of the settlement agreement, if you take it to the tribunal after we've paid you the money, then we will want the money back, and we want that money back with our legal costs and any expenses that we incur to get it back. That is fine, but in certain circumstances it doesn't wash. So for example, if you are doing an enhanced redundancy package where you're paying someone more money than they would get under the statutory entitlement, then if you're say paying someone 15 grand but they would have got 10 grand statutory redundancy, you can't tell them that they have to pay back their 15 grand, because you would have had to pay them 10,000 quid anyway to make them redundant. So you'd have to say something in the contract to the effect of that we will pay you the difference between the compensation payment and your statutory redundancy payment, which is whatever. Okay.
So 8, reaffirming restrictive covenants. So as an organisation, you may wish to include a clause within the settlement agreement to reaffirm restrictive covenants, which may be in an employee's contract of employment. Then there needs to be some sort of consideration in doing so. So in order for restrictive covenants to carry more weight, you should offer some form of incentive to the employee, which is normally in the form of financial consideration. And generally, the more money that you kind of add in the agreement, the more weight the restrictive covenants will carry. Just to flag that if you are offering financial consideration for reaffirming the restrictive covenants, tax and national insurance will be payable on this sum as well. So the decision to include a reaffirmation clause should be assessed and considered on a case-by-case basis. And if as an employer you've got any concerns about the enforceability of restrictive covenants within an employee's contract of employment, obviously we recommend just seeking legal advice, and obviously this is something we can assist with. Okay, 9, my final one, just sloppy drafting errors. They are easy to make, and particularly if you're using old precedents or using a template and you think, oh, I don't need that clause now because we're not making a termination payment in this one, and then suddenly every time it refers to the repayment of the termination payment, and you agreeing to accept the termination payment in waiver of the claims, and that clause is actually no longer there. It kicks all the numbering, the paragraphs out of sync, but also it doesn't actually make sense, because how can you waive your claims in exchange for a termination payment that you're not actually receiving? And these are all things that we see. So people that, oh, just delete that, I don't need that. But how it impacts the whole contract is important to note.
things that we've seen, would you believe people being sent the agreement with the wrong name on, wrong address, wrong employer? We've even, and then particularly, change at the top on the front cover or the name, the address, but when you get further down and, suddenly the executive CEO is, the cleaner, paragraph 7, and that there's all things like that. It just makes it look, unprofessional. It doesn't look good for your business. The solicitor will then be, cheesed off. They're going to have to go back to you. They may say, well, you've done a poor job drafting it. I've had to incur further cost. I want a bigger bill for my time to make it right, or you make it right, and you spend your time. You may then have to go to your lawyer and get it right. If you've had to go first time and it's not been drafted properly. So all things like that. It's just, it's important to double check it, proofread it before it goes out, and make sure that you're using the right form. Also, some things you can't waive under settlement agreements, and from time to time we see people sneaking in things at the bottom of the list which you think you can't actually do that, and they end up getting struck out in terms of the claims that you think they're not appropriate. Natalie's talked about the specified claims. Things that you sometimes see people trying to do is waive a claim for failing to consult or inform and consult on TUPE. That cannot be waived under a settlement agreement. So even if you put it in, it wouldn't be enforceable. PI claims is the other one as well. You might be familiar with the wording where you waive any PI claims that you have knowledge of, but you don't waive the kind of industrial disease type claims that might arise in the future. I have to say, even though that clause is in agreements, it's not PI lawyers will probably turn their nose with that and say, actually, they haven't had specific advice on the PI claim and the waiver of it and the settlement of it, and actually probably a court would find that it's not enforceable anyway. So don't get too tied up about PI claims, because there's not much you can do. But most employers will have employer liability insurance, which protects them from those. Anyway, well, you definitely should, and it's a legal requirement.
So 10, reasonable offers of settlement and legal fees. So ultimately, as an employee, if you don't make a reasonable offer of settlement, the advisor is likely to advise the employee that they may have grounds to negotiate, or even suggest it may be in the employee's interest to bring an employment tribunal claim. So by not making a reasonable offer initially, you're likely to incur more costs and delay finalising the agreement itself, or ultimately you could find yourself in the employment tribunal. So touching on legal fees, Paul mentioned it's not a legal obligation to provide a contribution to legal fees, but it is standard practice. £250 plus VAT seems to be the historic fee, but this is just becoming quite unworkable, and realistically it should be a £350 plus VAT. And I think a judge recently said it should realistically be £500 plus VAT. So just consider that when drafting the agreements as well.
Yeah, absolutely. So that's our top 10. And for all of those of you attended, we'll send a list of those bullet points out, things to kind of watch out for. In terms of what to take away, I think the most important thing is to remember that a settlement agreement is not just a thing that you download from a file every now and then and change the names and addresses and the figures that you're going to pay someone. It does need thought, particularly in relation to specified claims. Drafting thought, making sure that it's drafted appropriately for the employee that you're offering it to. It's not just a case of amending a precedent. It does need thought, and the problems it creates for when the employee solicitor gets hold of it and has to consider the poorly drafted agreement, or an agreement which doesn't actually work in requirements with the law, or has tax issues. It just creates, you again get a letter back from a solicitor saying this hasn't been drafted properly, or and then it's your time or you're going to end up paying a bigger contribution to the employee, because the employee is saying, well, it's not my fault, you gave me a poorly drafted agreement. So I hope that was helpful. I can see there's a few questions down here. Let's see. Could the employer meet the cost of the tax and national insurance? Yes, so there's nothing harm to topping up the tax and national insurance element. So obviously a tax-free payment won't have tax and NI contributions if the notice has been paid separately. But if you are making a lump sum, you can draft the agreement so that the employer effectively tops up that figure. Let's just see. Andy, how many months pay would the severance payment be? I can't quite see what the first question is there. Sorry, I can't read the thread there. Laura, can you waive the right to make a DSAR under the settlement agreement? This is a bit of an interesting question, because as obviously making a data subject access request is a statutory right, and if someone wants to exert that right in the future, having waived the right under a settlement agreement, then I don't actually see there would be an issue, and I think probably they would be allowed to do it. I think what you can say is that they don't intend to make one at the time of signing. Attach what weights that you will. You could potentially put something into the contract to say, if you, whilst we're not stopping you from doing it, if you do it, there will be you'll have to repay the money, for example. But my view really is because of the sort of the reasons that people make data subject access requests, sort of permanently waiving the right to do so from an employer would probably be deemed, in my view, unreasonable. So I think it'd probably go too far to have that waiver in place entirely. But obviously there's no harm in putting it in. I think we have it in our kind of, the one that we draft has that clause in as a deterrent. But if push came to shove and you ended up with an ICO type report, then you might find yourself having to do it anyway. I think probably on the basis that it was done related to something else, not as if I'll sign the settlement agreement and then the following day I'll make a DSAR because I want to be a pain in the bum. I think if it was done with good intention and in the right way to get the right information that individual needed, then I think probably you would be required to deliver that information. Okay. I'm not sure there's any more questions on the chat. No, doesn't look like it. I don't know if anyone's got any shout out questions, or we can call it a day there. No. All right. Well, thank you very much for joining. As I say, we'll send over the list by the end of the week and get that out so you could use that. Obviously, if you have got contracts which you think need checking and improving, then I think it's probably a good, if you are thinking of offering people settlement agreements in the near future, it's probably not a bad time to get a properly drafted one. Even if you are going to use a template, I've seen ones recently where people are paying £30,000 tax-free plus 6 months notice, and they're using the downloaded ACAS precedent. So, it does pay and give you much more protection if you have a properly drafted one. And obviously, if you'd like us to do it, we're the guys. So that'd be great. All right. Well, I hope that was helpful. Thanks very much.
Thanks. Bye.